Hi, my name is John Culhane. I'm a professor of law at the Widener University School of Law in Wilmington, Delaware. And I'm going to talk a little bit about the decision today by the Federal Court of Appeals for the Ninth Circuit upholding what a lower court did in striking down Proposition 8 as unconstitutional. So I'm going to raise this in the form of a few questions which I'm then going to answer. And the first question is, what is Prop 8 and what is this all about? So Prop 8 was a decision by the voters of California to strip same-sex couples of the right to marry, which the California Supreme Court had said they enjoyed. This then resulted in a lawsuit that was filed by some plaintiffs who claimed that their right to marry had been unconstitutionally infringed. There was a lower court decision that agreed with that, and today's decision by the Federal Court of Appeals is the next step in that process. So what did the Court of Appeals hold? The Court of Appeals held that Proposition 8 was in fact unconstitutional, but not really for the reasons that people expected. So typically in these inequality cases or cases in which inequality is alleged, you have courts talking about two clauses of the Constitution, either equal protection under the laws or due process. In this case, the court really didn't think that it had to go into either of those in any kind of detail, because what it decided instead is that when a group of people already has a right, as the same-sex couples in California had before Prop 8, then if that right is taken away, the court has to scrutinize why that happened. And in doing that, the court really tracked a Supreme Court decision called Romer versus Evans very carefully. And in that case, what the court decided was that the Colorado voters were not able to pass an amendment to their state's constitution stripping gays and lesbians of protection they had under state laws. And tracking that decision, the Federal Court of Appeals said once same-sex couples already had the right to marry, then to strip them of the label marriage while allowing them to retain all of the same rights and responsibilities of marriage, which they had enjoyed under the idea of domestic partnership, was unconstitutional. And what the court said is that the voters could have had no legitimate reason for doing that except for animus toward gay and lesbian people. So the case now goes probably to the full Ninth Circuit en banc, or else it will go directly to the U.S. Supreme Court. And it will be interesting to see what the Supreme Court does with this case, since it was decided on such narrow grounds. The court might decide that one sort of easy way out is to uphold what the Ninth Circuit did, and therefore states could still have bans against same-sex marriage, but they couldn't first allow same-sex marriage and then take it away unless they had a very good reason.